Robyn Rowen, your BIGiMN Minnesota lobbyist with a post-session legislative update. You've all seen the headlines and you've heard the sound bites about what transpired this session. You've probably heard it described as transformational in terms of the investments made in education, childcare, affordable healthcare, climate, benefits for workers, and preventing homelessness, just to name a few issues. You've probably also heard the session described as bonkers in terms of the amount of spending, government growth, and tax increases. In my opinion, the two are not mutually exclusive. The session was both transformational as well as more than a little bonkers. Today, we're going to go behind the headlines to discuss how two of the session's marquee issues, paid family and medical leave and the legalization of adult use cannabis, may impact you and your clients. Paid family and medical leave has been a DFL priority for years, but it took the trifecta to make it possible. Accordingly, there was never a question of whether a paid family and medical leave bill would pass, only what the final product would look like. Over the course of 22 committee hearings, we were able to make some significant improvements to the bill to make it easier for employers to implement. But the struggle was real. Much like with the rest of the session, the PFML advocates were not particularly sympathetic to the current concerns of the business community. And beyond that, there was an overall distrust of the private sector. For example, when Republicans offered an amendment to allow the state to outsource the administration of the program to a private insurance company, advocates in the room actually booed and had to be forcibly removed from the hearing room. Here's what you need to know about the new program. It requires employers to provide 12 weeks of leave for an employee's own serious health condition. It also requires 12 weeks of leave for family leave, which includes bonding as well as leave to care for a family member with a serious health condition. However, an employer cannot take more than 20 weeks of leave per year. This was a victory as the original bill allowed up for 24 weeks of leave per year. Employers will have a choice on how to implement the program. They can enroll their employees in the state plan, which will cost a 0.7% increase in the employer's payroll tax. Employers can require their employees to contribute up to half that amount. Employers can also satisfy the mandate by offering a private plan. The private plan can be provided by an insurance company or on a self-insured basis, so long as the benefits offered by the private plan are at least equivalent to the benefits under the state plan. This was another big win, as there was pressure from the advocates to eliminate the private option, both directly and by making it so unwieldy that employers would be forced to use the state plan. With respect to small employers, the bill authors were unwilling to completely exempt them from the leave mandate, as some states have done. However, we were able to convince legislators to provide a premium discount to employees with less than 30 employees. There will also be grants available to help small employers temporarily replace workers on leave. Benefit payments and the payroll tax increase for those in the public plan will not kick in until January 1st, 2026. Now, you may have figured out and done the math that there's an election between now and then, but neither the governor's office nor the Senate are on the ballot. This means that even if Republicans flip the House, while they may be able to refine the program, they will not be able to repeal it. So paid family and medical leave is here to stay. As you know, the legislature legalized adult use cannabis this session, making Minnesota the 23rd state to do so. Legislation will be phased in, however. So, starting on August 1st, it will be legal for individuals 21 and over to possess, use, and grow cannabis at home. With respect to commercial cannabis activity, the new Office of Cannabis Management will not grant licenses until next summer, with retail sales expected to begin by the end of 2024. While the cannabis bill is just shy of 200 pages and went through over 24 committees, there are still several issues that are relevant to insurance agents that weren't fully addressed. I guess you could say the bill is half-baked. I promise that is my only bad pot pun in this entire video. First issue is the issue of minimum insurance limits for retail cannabis businesses. Currently, the only minimum insurance limits included in the bill are those required for a cannabis transporter license. Since licenses will not be issued until next summer, we have time to amend the law. Our plan is to bring forward a proposal next year establishing minimum limits for commercial general liability, products liability, and gram shop, which is the cannabis version of dram shop coverage. That's not my bad pun, that's actually what they call it. We will be partnering with the trial bar on this proposal as they agree that these businesses need adequate protection to succeed. Politics makes strange bedfellows indeed. Cannabis issue involves the challenges legalization brings to the workplace. The new law prohibits testing of job applicants for cannabis use and the use of cannabis test results to make hiring decisions unless testing is required by federal or state law. However, the law does provide several exceptions to the testing prohibition, including peace officers, firefighters, positions working with healthcare patients or children, positions requiring a commercial driver's license, as well as safety-sensitive positions, which are not defined, but they will give the employer some control over when they can test. In addition to testing, there is also the issue of impairment on the job. While the bill allows employers to ban the use and possession of cannabis in the workplace and to take disciplinary action against employees that are using or are impaired due to cannabis at work, we all know that there is no objective measurement or accepted standard of what constitutes impairment. And current tests only measure the presence of THC and not the level of impairment. Unfortunately, the DFL majority did not feel this issue was worth holding up legalization for. Next year, we will partner with the IFM to bring legislation to provide additional protections for employers and comp carriers. So let's return to my original premise. There are transformational and crazy elements even within individual bills. If you have any questions about the bills I covered today or other pieces of legislation, please reach out. Lastly, I would be remiss if I didn't mention that it is now officially fundraising season. The first fundraiser invitation actually arrived in my email box minutes after the session officially adjourned. As you can see, it is more important than ever that we are in St. Paul advocating for you and your clients. So please consider a contribution to our PACs. Thanks for listening, and I'll see you next time.